I have presided over thousands of courtroom disputes. I have seen forged signatures, fake receipts, invented witnesses, manufactured stories. But there is one case I still remember because the deception walked into my courtroom wearing a suit, carrying a briefcase, and introducing himself as an attorney. And sitting right beside him was a woman named Karen, a very confident Karen, a very loud Karen. A very overweight Karen who seemed absolutely convinced that she had discovered a loophole capable of fooling everyone in the room. She was wrong, spectacularly wrong, because before that hearing ended, the truth unraveled so fast that even I struggled to believe what I was witnessing, and the moment her so-called lawyer made one tiny mistake, the entire courtroom realized they were watching a disaster unfold in real time. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also, comment below and tell us where you are watching this video from. Now let me take you back to where this case truly began. The plaintiff was a woman named Olivia Bennett, 38 years old, single mother, recessed nurse, calm, respectful, prepared. She arrived carrying a thick binder organized with color-coded tabs. Years on the bench teach you to notice preparation. People who know the facts usually bring documents. People who know they are lying often bring confidence. Across the courtroom sat Karen Mitchell, 45 years old. He was it. Expensively dressed Diane's handbag, large diamond ring, perfectly styled hair, and an expression that suggested the entire proceeding was beneath her. Karen wasn't alone. Beside her sat a man in a charcoal gray suit, early 50s, silver tie, leather briefcase, expensive watch. He introduced himself as Richard Holloway, attorney for the defendant. That immediately caught my attention, not because attorneys are unusual, because this particular courtroom proceeding did not permit attorney representation. Everyone involved had been informed of that weeks earlier. I looked at him, then at Karen, then back at him. Interesting, very interesting. "Sir," I said, "what is your role here today?" He smiled confidently. "I am here to assist my client," not answer the question, assist my client. That wording stayed with me. Years on the bench teach you that evasive answers often arrive before larger problems. I nodded slowly, then turned toward Olivia. She explained the dispute. According to her, Karen hired her to coordinate a charity fundraising gala benefiting pediatric cancer patients. Olivia organized vendors, scheduled venues, managed sponsors, that's what logistics. The event was successful. More than 200 guests attended. Thousands of dollars were raised. Then Karen refused to pay the agreed event management fee, $26,000, a significant amount of money. Karen claimed Olivia breached the agreement. Olivia claimed Karen simply never intended to pay. A fairly straightforward dispute, at least initially. Then Karen interrupted immediately. She ruined everything. Olivia stopped speaking. I looked toward Karen. "You will have your turn." She lost sponsors. "You will have your turn." She embarrassed me publicly. "You will have your turn." Karen folded her arms and leaned back. That gesture became familiar very quickly. People often create physical barriers when they feel threatened. Karen did it repeatedly. The man beside her remained silent, watching, observing, almost too carefully. That bothered me, because real attorneys usually focus on notes, evidence, and legal issues. This man spent most of his time studying reactions, not documents, reactions. Interesting, very interesting. Olivia continued. She presented contract SACOMs, invoices, .sex messages. Everything appeared organized and authentic. Then she submitted photographs from the gala. I reviewed them carefully. The event looked successful. Packed tables, corporate sponsors, auction displays. Decorations, professional staging, nothing suggested disaster. I turned toward Karen. You claim the event was ruined? Yes. How? The sponsors hated it. Which sponsors? Most of them. Names. Silence, a long silence. Then Karen glanced sideways toward Richard Holloway, the supposed attorney. He leaned forward slightly and whispered something. Karen immediately answered. Multiple sponsors complained. Interesting. Not names, not evidence. Complaints, vague complaints. Years on the bench teach you that vague answers often exist to avoid specific lies. I asked another question. Do you have written complaints? No emails? No messages? No statements? No. The courtroom became quiet. Olivia simply stood there, calm, baton. Prepared, Karen became visibly irritated. That contrast mattered because innocent people often want facts examined. Dishonest people often want emotions examined. Karen seemed much more interested in emotions. Then I noticed something. Every time Karen struggled with a question, she looked at Richard every single time, not occasionally, every time. That was unusual, very unusual. People consult attorneys. Of course they do. But this felt different, almost rehearsed. Like she was waiting for permission to answer, I continued reviewing evidence. Then I found an email, a very interesting email, sent 3 days after the gala. I read it once, then twice, then a third time, because the language directly contradicted Karen's testimony. I looked up. Miss Mitchell. Karen shifted in her chair. Yes. Did you send this email? Her confidence faded slightly. Yes. I read it aloud. Olivia, the event exceeded expectations. Thank you for making everything run so smoothly. The courtroom became silent. Olivia said nothing. Karen immediately leaned forward. That was before I knew what happened. Interesting. Very interesting, because I had heard that explanation before. Many times the problem was that she still couldn't explain what happened. What exactly did you later discover? Karen hesitated, then looked toward Richard Agan. He adjusted his tie, a tiny movement barely noticeable. But I noticed Karen immediately answered financial irregularities. Now that caught my attention. Financial irregularities, specific words, unexpected words. I turned toward Olivia. She looked genuinely confused, not performative confusion, real confusion. Did anyone accuse you of financial misconduct? No, Your Honor. I looked back at Karen. What irregularities? Karen opened her mouth, then stopped, then looked at Richard again. And that's when I noticed something disturbing. The man claiming to be an attorney suddenly looked nervous. Not Karen, him, for the first time all morning. And when I asked a very simple question about his bar registration number, the color disappeared from his face. The moment I asked for his bar registration number, the courtroom changed. Not dramatically, not loudly, quickly. But experienced judges learn to recognize those moments, the moments when confidence suddenly becomes calculation. The man who introduced himself as Richard Holloway sat perfectly still, too still. His hand remained on the briefcase, his smile disappeared, and for the first time that morning, he stopped looking at Karen and started looking at the exit. That bothered me. Years on the bench teach you that innocent people usually look toward evidence. People with something to hide often look toward escape routes. I folded my hands. Mr. Holloway. He cleared his throat. Yes, Your Honor. What is your state bar number? The silence that followed lasted only a few seconds, but it felt much longer. Karen looked at him. He looked at me, then back at Karen. Interesting, very interesting. Because attorneys answer that question every day, immediately, without hesitation. It is basic professional information, yet Richard appeared to be searching for it inside his own memory. I'm licensed in multiple jurisdictions. He finally said, not an answer, an evasion. I noticed, so did the spectators, so did Karen, and for the first time she looked slightly concerned. I asked again, "What is your bar number?" Richard adjusted his tie. Agin, a nervous habit, perhaps, or a stalling tactic. Either way, it was becoming noticeable. I don't have it memorized. The courtroom became quiet. Years on the bench teach you that many lies fail because they ask too much from common sense. A practicing attorney may forget many things. Their own professional registration is rarely one of them, especially not when sitting in a courtroom. I looked toward the clerk. "Would you please check the attorney registry?" Richard immediately spoke. "That won't be necessary." Interesting, very interesting, because people who belong in a registry are rarely afraid of someone checking it. The clerk began typing. The room remained silent. Karen was staring at Richard now, not me, not Olivia, Richard. That told me something important. Until that moment, she believed he would solve her problems. Now she was wondering whether he had become one. I turned toward Olivia. She appeared just as confused as everyone else, which I found revealing. If this had been some coordinated plan between the parties, Olivia would have shown recognition. She didn't. She looked genuinely surprised. That increased my confidence that whatever was happening involved Karen and Richard, not her. The clerk continued searching, then stopped. She checked again, then a third time. I watched Richard carefully. His jaw tightened, his fingers gripped the briefcase, and suddenly I remembered something. Years ago, I presided over a fraud case involving forged credentials. The defendant displayed exactly the same behavior when documentation became unavoidable. Not panic, preparation for panic, a subtle but important difference. Then the clerk looked up. "Your Honor, I cannot locate an attorney named Richard Holloway in this state." The room froze. Karen blinked once, twice, then stared directly at Richard. Richard forced a smile. A clerical error. Interesting answer. Not, there must be a mistake. Not, check another jurisdiction. A clerical error. Very vague, very convenient. I leaned forward. "Which state are you licensed in?" Another pause. Then, several. Again, not an answer. The spectators were beginning to notice the pattern. Every question received a cloud. Never a fact, never a number, never a document, only clouds. And clouds disappear when evidence arrives. I requested identification. Richard slowly removed a wallet. The movement felt reluctant. That caught my attention. People confident in their identity usually provide identification quickly. Richard handled the request like someone handing over evidence. The court officer brought the card to my bench. I examined it. Interesting, very interesting, because the card looked impressive, professional, official, laminated, but something was wrong, the typography, the spacing, the seal, tiny details. Most people would never notice. I did. Years in court expose you to thousands of legitimate credentials. Counterfeits rarely survive close inspection. I looked toward Richard. Where was this issued? He answered immediately, too immediately. People telling the truth often think before answering. Liars often prepare answers in advance. That distinction matters. I handed the identification to the officer. "Please verify this." Richard's face changed, not dramatically, just enough, a small shift. The kind that appears when someone realizes the next step cannot be controlled. Karen noticed it too. And that is when something unexpected happened. She began distancing herself psychologically. That fascinated me. Moments earlier, she depended on him. Now she leaned away from him. Literally, the physical distance increased. Only a few inches, but enough. People instinctively move away from danger when they recognize it. Karen was recognizing it. The officer left to verify the credentials. The courtroom waited, and waiting is powerful. People underestimate silence. Silence forces thoughts to grow louder. Karen sat quietly. Richard sat rigidly. Olivia remained composed. I reviewed the evidence from the original dispute, the contracts, the invoices, the emails, and the more I reviewed them, the more curious I became because a second pattern was emerging, a pattern unrelated to fake attorneys. Karen had repeatedly claimed financial irregularities, yet every time I requested documentation, she relied on Richard to answer, almost as if she never understood the accusations herself. That observation bothered me because it suggested the allegations may have originated somewhere else, someone else, perhaps the man sitting beside her. Then I found a series of messages exchanged between Karen and Richard before the hearing. Interesting, very interesting. The timestamps were recent, extremely recent. The content was even more interesting. I read several silently, then another, and suddenly my concern grew because the messages didn't read like communications between attorney and client. They read like instructions, specific instructions, what to say, what not to say, which phrases to repeat, which accusations to make. Karen saw me reading. The color drained from her face immediately because she recognized the messages and she knew exactly what was inside them. Then the court officer returned. He approached my bench, handed me a verification report. I reviewed the first page, then the second, then looked directly at Richard Holloway, or whoever he really was, because according to the report, there was no attorney named Richard Holloway anywhere. And the name printed on his identification belonged to a man who had been dead for almost 7 years. I remember the exact moment the courtroom stopped being about unpaid event fees. It happened when I looked up from the verification report and realized that the man sitting beside Karen Mitchell was not simply unlicensed. According to the records in front of me, he appeared to be using the identity of a dead man. The room became silent, not ordinary courtroom silence, the kind of silence that arrives when reality suddenly becomes stranger than anyone expected. Karen stared at me. Richard, if that was even his real name, stared at the table. Olivia Bennett looked completely stunned, and honestly, so did I. Years on the bench teach you to expect deception. But this felt different because impersonating an attorney is one thing. Using the identity of a deceased attorney is something else entirely. I folded the report carefully, then looked toward him. What is your real name? The question hung in the air. No answer. Interesting, very interesting. People lie for many reasons. But complete silence often means a person has reached the point where every available answer creates a new problem. He sat motionless. The court officer moved slightly closer. The spectators watched every second. Nobody wanted to miss what happened next. I asked again, "What is your real name?" Another silence. Then finally, Michael. Only Michael, no last name. No explanation, just Michael. That answer immediately caught my attention because partial truths often appear when complete lies become impossible. I looked toward Karen. She appeared terrified. Not angry, not embarrassed, terrified. That observation bothered me because until that moment, Karen had seemed confident that Michael would protect her. Now she looked like someone realizing she had trusted the wrong person. I turned back toward him. "Michael, what?" He looked away, then said nothing. Again, the court officer requested identification. Additional identification, not the fake attorney credential. Something real, something verifiable. Michael slowly removed a driver's license. The officer handed it to me. I reviewed it. Interesting. Very interesting, because the name did not match, not even close. His real name was Michael Grayson, not Richard Holloway, not an attorney, not licensed in any jurisdiction. And according to the accompanying records, he had prior fraud convictions. The spectators gasped. Olivia covered her mouth. Karen closed her eyes, and suddenly everything started making sense. The coaching, the instructions, the rehearsed answers, the financial irregularity allegations, the fake legal expertise, all of it. I remember thinking something at that moment. Karen believed she brought a weapon into court. Instead, she brought evidence. Evidence against herself. Years on the bench teach you that dishonest people often make one critical mistake. They become so focused on defeating the immediate problem that they ignore the larger risks they are creating. Karen wanted someone who could sound like a lawyer. Apparently, she never stopped to ask whether he actually was one. Then I returned to the text messages, the messages between Karen and Michael, and what I found disturbed me. Not because they contained legal strategy, because they contained something else. Manipulation, pure manipulation. After message instructed Karen how to create doubt, how to attack credibility, how to avoid direct answers, how to delay proceedings, how to make Olivia appear dishonest. Interesting, very interesting, because none of those messages discussed facts, not one. The focus wasn't truth. The focus was confusion. That distinction matters. Truth seeks clarity. Deception seeks confusion. And Michael's messages were filled with confusion. Then I found one particular message, a message sent 3 nights before the hearing silently. I read it silent, then again, then a 3rd time, because it changed everything. I looked toward Karen. The moment she realized which message I had found, the color vanished from her face immediately. That reaction alone told me the message mattered. Mitchell, no answer. Did you receive this text? A pause. Then, yes. The room became silent. I began reading. Do not bring the real contract. Bring the revised copy. Nobody moved. Nobody spoke. I continued. The original version hurts your case. The spectators exchanged shocked looks. Olivia stared directly at Karen. Karen stared at the table because there it was, not poor judgment, not confusion. Intent, documented intent. Years on the bench teach you that most courtroom lies collapse long before the final ruling, usually because someone writes something down. People forget how dangerous written words can be. Memories change, documents don't. I looked toward Olivia. Do you have the original contract? She immediately nodded. Yes, Your Honor. Interesting. Very interesting, because suddenly we had 2 contracts, one original, one revised, and Karen appeared desperate to keep them separate. That raised a question, a very important question. What exactly had been changed? The court officer collected both documents. I placed them side by side, then began comparing them. The spectators leaned forward. Michaels stopped looking at Karen. Karen stopped looking at anyone, and the more I compared the pages, the more concerned I became, because the differences were not minor, not formatting, not corrections. Entire clauses had changed. Payment obligations, deadlines, responsibilities, critical sections. Someone had altered the agreement substantially. Then I noticed something else, the signature dates. Interesting. Very interesting. The dates didn't match up. In fact, one signature appeared to have been added weeks after the document was supposedly finalized. The room became silent again. I looked toward Michael, then Karen, then back toward the contract, because suddenly a much bigger question appeared. Who changed the document? And more importantly, who believed they could get away with it? Then the court clerk quietly approached my bench carrying a new report. I reviewed the first page and immediately felt a chill because the forensic review had already begun. And according to the preliminary findings, the signature on the revised contract might not belong to Olivia Bennett at all. I remember the silence that followed, not because people were confused. because they understood exactly what the implication was. A fake attorney was one thing. A forged contract was something else entirely. The moment I read the preliminary findings, I looked toward Karen Mitchell. She didn't look surprised. That caught my attention immediately. Years on the bench teach you that innocent people react differently when allegations suddenly become more serious. They become alarmed, defensive, confused. Corin became still, agate. That same unnatural stillness I had noticed earlier, and every time I saw it, the same thought crossed my mind. She wasn't processing information, she was calculating. I placed both contracts side by side, the original agreement Olivia submitted, and the revised version Karen brought into court. The differences were substantial, not technical, not accidental. Substantial. Entire payment clauses had changed, liability provisions had changed, deadlines had changed. The document had been transformed from a straightforward service contract into something far more favorable to Karen. Interesting, very interesting. I asked Olivia a simple question. Have you ever seen this revised version before today? No, Your Honor. The answer came instantly. No hesitation, no uncertainty, just no. That mattered. Because truthful answers often arrive naturally. Fabricated answers usually require assembly. Olivia didn't need assembly. Then I turned toward Karen. Who provided this version of the contract? Karen immediately looked at Michael. That told me everything. Not because it proved guilt, because it revealed dependence. People instinctively look toward the source of a problem or the source of a solution. Karen appeared unsure which one Michael had become. Michael avoided eye contact. Interesting, very interesting. Earlier, he had projected confidence. Now, he seemed focused on becoming invisible. People attempting deception often imagine success will feel empowering. What they don't anticipate is how quickly confidence disappears when documentation arrives. And documentation was arriving rapidly. I asked again, who provided this version? Karen finally answered. Michael found it. Not my attorney found it. Not Mr. Holloway found it. Michael. The illusion was gone now. Even Karen had stopped pretending. That observation fascinated me. Because once a deception collapses, people often abandon it surprisingly quickly. Maintaining a lie requires energy. Karen was running out. I turned toward Michael. Where did you find the contract? A pause. Then my files. Interesting answer. Not a good answer, but an interesting one. Which files? Another pause. Longer this time. Then silence. The spectators exchanged looks. The court officer watched carefully, and I noticed something disturbing. Michael's hands were shaking, not dramatically, slightly, but enough fear was beginning to surface. Real fear. That told me something important. People who fear embarrassment behave one way. People who fear discovery behave another. Michael looked like a man afraid of discovery. Then I reviewed the forensic summary again. The findings weren't preliminary, not final, but the indicators were concerning. Signature inconsistencies, dat fortunes, anomalies, noptetra conflicts. Interesting, very interesting nopperto. Many people forget about metadata. They focus on printed documents, date signatures, what they see. But digital records often tell stories people never intended to share. And according to the preliminary review, the revised contract may have been created only 3 weeks earlier, not months earlier, not before the dispute. 3 weeks earlier, the room became silent. I looked toward Karen. Her breathing changed, just slightly. But I noticed that reaction mattered because she already knew. At least partially. Then something unexpected happened. Olivia spoke. Quickly, respectfully, but firmly. Your Honor. I nodded. She continued. I think I know why they changed it. Interesting. Very interesting, because until that moment, Olivia had focused entirely on facts, not theories, not speculation, facts. That gave her words weight. I asked her to continue. She opened her binder, removed several pages, then handed them to the clerk. The documents reached my bench. I reviewed the first page, then the second, then the third, and suddenly another piece of the puzzle appeared. Email timestamps, events, invoices, sponsor payments, bank records, all connected, all organized, all documented. Olivia had done something many people never think to do. She preserved everything. Every email, every attachment, every revision, every version. Years on the bench teach you that organized records are often more powerful than dramatic testimony, because records do not panic. Records do not exaggerate. Records simply exist. And Olivia's records revealed something fascinating. The original contract version existed on multiple servers months before the gala occurred. The revised version did not. Interesting, very interesting, because now the timeline became extremely difficult to explain. Michael sensed it too. His face had gone pale. Karen looked increasingly frightened, and the spectators could feel the momentum shifting. Then I found the detail that changed everything: a digital author record. Most people would overlook it. I didn't. The revised contract contained creator information. The name attached to the file wasn't Olivia, it wasn't Karen, it wasn't Richard Holloway, it wasn't even Michael Grayson's. It belonged to someone else entirely, a name I had not seen before, a name that appeared repeatedly in a separate set of communications recovered from Michael's devices. I looked toward him, then toward Karen, then back at the file, because suddenly the forged contract wasn't the center of the story anymore. The center of the story was the person who created it. And according to the records, that person worked inside a document processing company that specialized in legal paperwork. The room became silent. I looked toward Michael. What is your relationship with Daniel Mercer? The reaction was immediate. Michael's face turned white. Karen closed her eyes, and for the first time all day, neither of them attempted to answer. I will never forget what happened when I asked about Daniel Mercer, not because of what Michael said, because he said nothing. And sometimes silence is louder than any answer. The courtroom froze. Michael Grayson stared at the table. Karen Mitchell stared at Michael. Olivia Bennett stared at both of them. And I sat there watching a truth slowly emerge from the spaces between their words. Years on the bench teach you that people often prepare for questions they expect. They rarely prepare for the one question they never thought anyone would ask. Daniel Mercer was clearly that question. I looked down at the records again. The name appeared repeatedly: document revisions, .pel transfers, .patalogs, tunnel communications, and now it was impossible to ignore. Whoever Daniel Mercer was, he was connected to the forged contract. The room remained silent. I asked again, "What is your relationship with Daniel Mercer?" Michael swallowed. Karen looked away. Interesting, very interesting, because their reactions were synchronized, not planned, instinctive, the kind of reaction that occurs when two people already know the same dangerous truth. Finally, Michael spoke. "He does contract work," not an answer, at least not a complete one. I noticed. So did everyone else. "What kind of contract work?" Another pause, then documents. Interesting, very interesting. The answer was technically responsive, yet it explained almost nothing. Years of courtroom experience have made me highly suspicious of technically correct answers that avoid useful information. They usually indicate someone is walking carefully around a larger problem. And Michael was walking very carefully. I reviewed the digital records again. Then I found an email, a very interesting email, sent less than a month before the hearing. The subject line immediately caught my attention, contract revision. Interesting timing. Very interesting timing. I opened the message, right at once, then again, then a third time. Because I wanted to be absolutely certain. I looked toward Michael. The color had completely disappeared from his face. That reaction alone told me the email mattered. Then I looked toward Karen. She already knew. That much was obvious. I began reading aloud. Use the older signature sample. It matches better. The room froze. Nobody moved. Nobody spoke. Even Karen appeared stunned hearing the words read aloud. I continued. The client won't know the difference. The spectators gasped. Olivia slowly covered her mouth. Michael closed his eyes. And there it was, not suspicion, not theory, not inference, documented intent. Years on the bench teach you that most deception collapses when planning enters the record. People can argue about memory. They can argue about perception. They can argue about misunderstandings. It becomes much harder to argue about written instructions, especially instructions like those. I continued reviewing the communications, and they only became worse. Every page added another piece, another explanation, another connection. Then I found the message that changed everything. The message that created the viral courtroom moment people would talk about long after the hearing ended. I remember staring at it for several seconds, because even after everything else, I could hardly believe someone had written it. I looked toward Michael, then toward Karen, then back at the screen. Did either of you write this? Neither answered. Interesting. Very interesting. Because moments earlier, they attempted explanations. Now they attempted silence. That transition matters. People usually stop talking when the truth becomes impossible to improve. I displayed the message on the courtroom monitor. The spectators leaned forward. The court officer watched carefully. Olivia looked confused. Then she saw it, and her expression changed immediately. The message read, "If the judge sees the original contract, we're finished." The room exploded, gasps, whispers, shock, actual shock. Even after everything else, that sentence hit differently, because it revealed awareness, not confusion, not misunderstanding. Awareness. The writer knew the original contract existed. The writer knew the revised contract was dangerous. And most importantly, the writer knew exactly what would happen if the truth appeared. I looked toward Michael. He appeared defeated, completely defeated. Then something unexpected happened. Olivia began crying, not loudly, not dramatically, quickly. The kind of crying that comes after months of frustration finally collided with certainty. I understood why. For months, she had probably wondered whether she made mistakes, whether she forgot something, whether she could have prevented the dispute. Now she was learning something painful. The dispute was never about performance. The dispute was never about the gala. The dispute was manufactured. That realization can be devastating. Then the federal investigator, who had been quietly observing the hearing, stood. The room immediately became silent. He approached my bench, handed over another document, and I remember feeling a chill as I read it, because suddenly the forged contract wasn't the biggest problem anymore, not even close. The investigators had recovered deleted messages, hundreds of them, and among those messages was evidence that Daniel Mercer wasn't merely creating forged contracts. He had been creating them for years. For multiple people across multiple disputes in multiple states. Interesting, very interesting. This wasn't an isolated incident. It wasn't a desperate last-minute mistake. It appeared to be a business built around manufactured legal documents. The room became silent again. I looked toward Karen, then toward Michael, and finally toward the investigator. "Have you located Daniel Mercer?" The investigator nodded. The spectators leaned forward. Nobody moved. Nobody spoke. Then he delivered a sentence that made Karen begin shaking, actually shaking. Daniel Mercer was arrested this morning. The room froze. Michael lowered his head. Karen closed her eyes. And then the investigator said something that completely shattered what remained of their confidence, something even they did not expect. Daniel has already provided a statement. I remember looking toward Karen because in that exact moment, she knew he had told investigators everything, and the first page of that statement was sitting in front of me, waiting to be read. I remember holding Daniel Mercer's statement in my hands and realizing that the hearing had traveled far beyond where it began. What started as a dispute over a $26,000 event management fee had uncovered a fake attorney, a forged contract, and now a document specialist who had already begun cooperating with investigators. The courtroom was silent, not because people were confused, because they understood the truth was finally arriving. And once the truth gains momentum, it becomes very difficult to stop. I looked toward Karen Mitchell. She sat motionless, no interruptions, no objections, no confidence. The woman who entered my courtroom convinced she had an advantage now looked like someone waiting for a verdict she already knew was coming. Michael Grayson looked even worse. The man who spent the morning pretending to be attorney Richard Holloway now avoided eye contact with everyone. Years on the bench teach you something interesting. People can maintain a lie for months, sometimes years, but once exposure begins, maintaining the performance becomes exhausting. That exhaustion was visible now. I opened Daniel Mercer's statement. The first page immediately confirmed what the evidence had already suggested. The revised contract was fabricated, not modified, not corrected. Fabricated cried weeks before the hearing. Specifically for the dispute, the room remained silent. I continued reading. Daniel explained how Michael contacted him, how payment was arranged, how language from the original contract was altered, how signatures were inserted, how metadata was manipulated, and how the document was ultimately delivered. Every step was documented. Every step was explained. Every step connected directly back to Michael, and then to Karen. That was the moment I looked toward Olivia Bennett, because throughout the entire hearing, she had remained remarkably composed. Most people would have become emotional much earlier. She didn't. She focused on records, facts, documents, evidence. And because she did, the truth survived. That observation mattered. More than many people realize, facts are often less dramatic than accusations, but facts tend to win. Eventually, I reviewed the remainder of Daniel's statement. Then I found the section that explained Karen's role. Interesting, very interesting, because it revealed something I had suspected from the beginning. Karen was not confused. She was not misled. She was not an innocent client receiving bad advice. According to Daniel's statement, Karen actively requested changes to the contract, specific changes, payment clauses, cancellation provisions. Performance standards. Every modification benefited her. Not accidentally, intentionally. The courtroom remained silent. I looked toward Karen. Do you dispute this statement? For several seconds, she said nothing. Then she slowly shook her head. No, just no. No argument, no explanation, no attempt to redirect the discussion. Years on the bench teach you that some of the strongest admissions arrive without words. This was one of them. I turned toward Olivia. You performed the event? Yes, Your Honor. The event occurred? Yes. The sponsors attended? Yes. The funds were raised? Yes. The answers came quickly, naturally, without hesitation. That mattered, because truth usually moves in a straight line. Deception rarely does. I issued my findings regarding the civil dispute. The contract was valid, the services were performed, the payment obligation existed. The fabricated contract carried no legal weight. Judgment entered in favor of Olivia Bennett, $26,000, plus allowable costs, clear, scored it by overwhelming evidence. Olivia lowered her head for a moment. Relief, not celebration. Relief, the kind that arrives after months of uncertainty. The kind that arrives when someone finally stops questioning whether the truth will matter. Then I turned toward Karen and Michael. The civil ruling was only one part of the story now. The larger questions would be handled elsewhere, by investigators, by prosecutors, by the appropriate courts. My responsibility was the dispute before me. But that did not prevent me from observing what had happened. And what happened was extraordinary. Karen believed appearance could replace evidence. She believed confidence could replace facts. She believed a fake lawyer could create enough confusion to make the truth disappear. Instead, the fake lawyer became the reason the truth surfaced. That irony stayed with me. Because courtroom deception often collapses under its own weight. The more complicated the lie becomes, the more opportunities it creates for exposure. And Michael pretended to be an attorney. That invited scrutiny. The scrutiny exposed the contract. The contract exposed Daniel Mercer. Daniel Mercer exposed everyone else. One lie pulled another into the light, then another, until there was nowhere left to hide. As people began leaving the courtroom, I watched Karen. She no longer looked arrogant. She no longer looked powerful. She looked tired, not because she lost. Because maintaining deception is exhausting. Eventually, reality demands payment, and reality always collects. I have presided over thousands of cases. Many involved larger sums of money. Many received greater publicity. Many were legally more complicated. Yet I still remember this one because it demonstrated a lesson that extends far beyond any courtroom. People often believe intelligence means finding ways around the rules. It doesn't. Real intelligence understands why the rules exist in the first place. Karen thought she had discovered a shortcut. A fake attorney, a forged contract, a manufactured defense. Instead, she built a trail, and every step she took left another piece of evidence behind. That is the lesson I carried away from that day. You can rehearse answers. You can create documents. You can hire people to tell your story. But if the facts are against you, eventually the facts win. Fat Karen walked into my courtroom believing her fake lawyer would fool everyone. She left understanding something she should have learned much earlier. The easiest person to deceive is often the person who believes they are the smartest person in the room, and on that day, she was dead wrong.